Hearing the appeal, Pearson against Primeo Fund.
My Lords, I appear with Francis Tregear, Queen's Counsel for the appellant, instructed by Matthew Gook and Chris Keefe of Walkers, of Cayman. The respondent is represented by Mr. Tom Smith, QC, instructed by Peter Hayden, Rocco Cecere and Christopher Levers of Moore and Ozens. The first intervener, Mr. Laurie Rabinowitz, QC, with Maximilian Scholte, instructed by Paul Kennedy of Appleby Cayman Limited, and the second intervener by Stephen Atherton, QC, with Jonathan Alcock, instructed by Stephen Barry of Nelson & Co. and Edward Davis of Stevenson Harbour.
Thank you very much. I notice your timetable, for which we're grateful. The only question in my mind, and if it's too late to reorganise, then don't, is whether it's sensible to have the respondent before the interveners. I notice you've allowed for the respondent to have a second bite of the cherry, but on the face of it, wouldn't it be more sensible to have the two interveners who are largely or to significantly on your side before the respondent? But if you're set in your ways, it probably will cause more trouble than help if you reorganise.
It's actually not my ways that really matter, because on any view I'm coming before everyone else. So.
Well, you plural in that sense.
Well, you plural in that sense. I mean, I noticed that...
But you could just, as I say, I don't want, if you've agreed something, it's inconvenient. But let's see how we go. But
bear in mind, my Lords, Reichmuth is actually not on our side. Natixis is, but Reichmuth is not.
No. Well, anyway, consider, we did discuss this, but as I say, I don't think we wouldn't want to insist on this. And as you say, we may have slightly oversimplified the position. Thank you.
Thank you, Madam. I'll perhaps leave it to others to discuss it.
Yeah.
As your Lordship said, there's an opportunity for the respondent to come back, so
yep.
Maybe there's enough there. So far as the difference between the parties, I'm sure your lordships have it. I mean, Primeo represent those who had a redemption date prior to the 1st of December, which largely means served a redemption notice prior to that date, before that date. The late redeemers are those who served between the 1st and the 12th of December, and the later redeemers, those who served after the 12th of December. We represent all those who aren't represented by Primeo, but now, for the purposes of this appeal, not Natixis or Reichmuth. But then there are a whole number of people who never served a redemption notice at all in the light of what had taken place. Yeah. What the interventions have done, which in one sense projects may find helpful, is it now focuses attention on the different categories of people, which wasn't the position in the Court of Appeal, and that does give rise now to some interesting questions. We say questions which demonstrate, amongst other reasons, why the Court of Appeal was wrong, because you don't get into these difficulties except on the basis of the Court of Appeal's approach, but we'll deal with that. As your Lordships know very well, the case concerns how much investors in the failed and fraudulent Madoff scheme will get on the winding up of Herald, a fund essentially devoted to receiving funds and investing them in Madoff. The Primeo, with whom the litigation originally started, were unsuccessful, we say, in withdrawing their funds prior to the insolvency. And that's critically important. We say what they are seeking to do is to enforce in the winding up claims which couldn't be enforced outside the liquidation because there was a valid suspension of redemption payments and because Herald didn't have the cash to make those payments, and which is, and this is crucially important, based on a wholly fictitious net asset value, a wholly fictitious NAV, which is the product of Madoff's fraud. The claim, therefore, we say, actually has no reality, and Primeo is, in effect, asking the courts to perpetuate Madoff's fraud. And it differs from the category of people who would actually receive their monies, where the principles of tree lies where it falls may come into play, because Primeo never did withdraw, never did succeed in getting their monies out. And of course, to the extent that Primeo succeed, then that is obviously, but I say it in any event because it's the fact, to the detriment of the other shareholders.
Can I just ask a point, Lord Smith? Are we getting a transcript?
Oh, I don't know.
Is one being taken?
Well, I can see one. Yes, we are. By email this evening, my lord.
Yes, just affects slightly the note one takes.
Understood.
Just slightly.
So we say this is by Primeo. It's really an opportunistic claim based on a NAV, if I can call it that, which they know to be wholly fictitious, and as a result of that fraud. In Fairfield Century, perhaps I can just take your lordships quickly to that. It's in the first authorities bundle at tab 1. Not tab 1.
Tab 8.
Tab 8, I'm sorry. First bundle, tab 8. And I actually only want to want to go to one passage, which is paragraph 3 of the judgment given by my Lord Sumption. Paragraph 3, if I may read this, it's inherent in a Ponzi scheme that those who withdraw their funds, I emphasise those words, before the scheme collapses, escape without loss, and quite possibly with substantial fictitious profits. The loss falls entirely on those investors whose funds are still invested when the money runs out and the scheme fails. And that's essentially the point I just wanted to draw attention to. I'm not suggesting that answers this case, but simply, factually, it's right. And the distinction is to be drawn, as Lord Sumption said, between those who withdrew their funds and those who didn't. We're in a category of case where they didn't. Primeo didn't withdraw their funds. They tried to. They served their notice, but they didn't, in fact, withdraw their funds. And so that's the case that we are concerned with. And there's other dicta to which I needn't turn, which would say that in those circumstances, the loss really needs to be shared, and that's not what Primeo are doing. What is the effect on the basis that the fund has at the moment about $461 million of assets. That may rise, of course, if there are further recoveries, but that's what it is at the moment. But on that basis, I've asked simply to illustrate to my lords the effect of the issues that are raised. If Primeo succeed in their contention, as they've done below, they will receive 100 cents in the dollar. I'm not picking up on any question of whether there may be interest, but I'm talking about the principle. Whereas the other investors, if Primeo scoops the pool in that way, will receive something like 15 cents in the dollar. If Primeo fails, then current calculations are they will all be in for about 24 cents in the dollar. But that just illustrates the significance of the point, and that's really the only reason that I'm...
But presumably there are other ordinary creditors, are there, or at least some, who weren't redeemable shareholders. They will be paid 100 cents.
They will be paid, of course.
100 cents in the dollar. So the question is whether these redeemable shareholders have done sufficient to place themselves in the position of ordinary creditors.
Well, the position now is that nobody actually suggests that's what they become, as I understand.
Well, there's a small postponement under Section 49G, is that right?
Well,
on that case.
The case has changed, and it's actually quite significant, because below, and particularly in the Court of Appeal, I was going to take your lordships to this, and I will do so, Primeo said that they were ordinary creditors, and they said ordinary creditors...
They say that in their printed case here as well. That's the whole basis of their...
Well, but they said then, and perhaps one has to see some modification in their printed case, that they rank pari passu with ordinary unsecured creditors. I understood, and perhaps I'm wrong, I'll hear from Mr. Smith, that he now accepts that they don't, and he adopts the position that the Court of Appeal took, that they qualify under Section 49G, which means that they rank behind ordinary unsecured creditors, but ahead of others, including other redeemable.
That's because their rights, although they have become to a debt, originate from the shareholding relationship.
That's it.
That's on the basis of what, of first instance authority, but which isn't being challenged apparently in front of us.
Well,
because Section 49G says so, I suppose.
Yes.
well, yes, but
I mean, I think we're sort of jumping a little ahead because, from my point of view, I think this is one of the really difficult issues to sort out, is where everyone now stands. Because I must say, as I read each sort of case, I sort of became slightly more, speaking myself, I was wondering where everyone was going to end up on these sort of
Yes.
points about priorities.
Well,
So I hope we'll come to that in a little more detail. In
yes,
due course.
well, I will, my lord, but one has got used to, in this court,
Jumping ahead.
jumping ahead, and I can make no complaint about it. I try my best to
You
keep
need
up.
to drag us all along the relevant
I'm going
piece.
to try and come back.
It adds to the pleasures if we all jump in different directions. Yep.
And I just wanted to remind your lordships that it was the Court of Appeal who said 49G.
Yes.
Mr. Justice Jones Andrew Jones didn't actually answer the question. So we have that difference. But I'm certainly going to come back to the question of ranking, because it's one of the pointers to why we say the construction put forward by Primeo and accepted by the Court of Appeal can't be right. And I will say that and this will run through my submissions, that Primeo have had to strain, if not actually subvert, some of the fundamental principles of corporate and insolvency law to get to the result they want. And during the currency of the case, they've changed their case on a number of important aspects. Actually, they've made statements which are diametrically opposed to statements they'd made before. And that, I suggest, is as a result of trying to fit the result that they're seeking to obtain into the structure of the law and the statute. But when it's very difficult to do that because of their starting point. Whereas if one takes the starting point that we do, which is to interpret the critical words in the section, have not been redeemed, as meaning, in effect, have not completed the redemption process, but particularly not having been paid, all these difficulties fall away. And I'll obviously develop this argument, our construction accommodates easily all the principles and rules, reaches conclusions which are in accordance with those principles and indeed commerciality and reasonableness. And I'm going to invite my lords, and to some extent it may be that my Lord Carnwath has already picked this up, as we go through the case, to note how often and how seriously and severely those who contend for a different result, contend to uphold the Court of Appeal, actually have to do these contortions to find solutions and workarounds and result in unnatural and strained arguments.
Yep.
And obviously to say, my lords, that if I can put it this way, when their analysis leads to odd conclusions and anomalies, if it works at all, that raises grave doubts about their starting point. And the way that the two new interveners have ended up taking positions rather illustrates the problem. So, before I get into the detail, I want to make one more general point. There is, we would respectfully suggest, and we wonder if this is what happened in courts below, a risk of being mesmerised by what the board said in strategic turnaround. Because it's important to note that strategic turnaround wasn't actually dealing with this question at all. And I'll take your lordships to it during the course of my submissions. What strategic turnaround was not dealing with was what's the meaning of the word redeem or redemption in the statute. It was concerned with what the meaning was in and effect was under the articles. And once one is not mesmerized by that and simply gives the words in the statute their ordinary and natural meaning, in our submission, this produces a coherent, a clear, comprehensive scheme, which also has regard to its commerciality and reasonableness. And there I'm just picking up language, actually, my Lord Neuberger, in the decision of just a few days ago in the Lehman Brothers case. I'll come to that. So I'm going to make my submissions really under 7 headings, why we say our submissions are to be preferred. Firstly, coherence. Secondly, consistency with policy. Thirdly, that it's supported by the language. Fourthly, that the Court of Appeal decision gives rise to anomalies and problems. Fifthly, changes in Primeo's case. Sixthly, the waterfall, and that may be to the extent we haven't ended up covering it under the previous headings before. And then seventhly, the point now raised by Reichmuth, which is a distinct point, which largely will be answered, no doubt, by Natixis, because they're particularly conscious of that. But we say that the Reichmuth point, which is to say that you don't take account of the fact that there was a suspension and that suspension was anticipated under the articles, means that you can continue to treat the redemption date as a date prior to the winding up, when in fact, by reason of the suspension, it plainly was not. By reason of the suspension, it's plain that the redemption date became after the winding up. If that point goes, then the whole of Reichmuth's point disappears. So let me, if I deal first of all with coherence, and I made a reference to what my Lord Neuberger said in the Lehman case, and I just want to show it. We've now got the judgment in a supplemental bundle of authorities at tab 58. And I just wanted to refer to paragraph 123. I'm just picking up on the words, and no doubt my lords may say out of context, but having referred to what Lord Justice Lewison said in his judgment that a limited solution is better than no solution at all, my lord continued, I would agree with that approach if the court had been simply seeking to arrive at as reasonable and commercial a result as possible. A partially unreasonable and uncommercial outcome would be preferable to a generally unreasonable and uncommercial outcome. However, when it comes to deciding the meaning of a legislative provision, judges are primarily concerned with arriving at a coherent interpretation, which, while taking into account commerciality and reasonableness, pays proper regard to the language of the provision interpreted in its context. And then made a reference to Mr. Justice David Richards, as he then was, judgment. So all I'm submitting is what one's looking for, because we are concerned with construction of the statute, is a coherent interpretation which pays proper regard to the language in its context, while taking account of commerciality and reasonableness. And if that is any form of test as to the result, then the Primeo construction fails on that. But whatever else coherence requires, it would include finding a useful purpose all of the provisions that the legislature has seen fit to include. And when one looks at Section 137 and 137.7 in particular, 37 and 37.7, it seems plain that what the legislature must have had in mind was a scheme to deal with the most important issues concerning redeemable shares, including priority and what the effect of insolvency or potential insolvency would be on the payment obligations. And it's striking that the conclusion to which the Court of Appeal came, and to which Primeo, as I understand it, support, is that, save to the extent it might be dealt with under 49G, the section that doesn't deal with priority, the provisions they rely on don't deal with priority at all, and important provisions which are in the section relating to priority and insolvency don't apply. Can I invite your lordships to take the statute? It's to be found in volume 2 of the authorities. Your lordships may already have marked it as well. Tab 43. I'll make reference during the course of my submission to particular aspects of this, but in looking at the section, one should, in our submission, bear in mind two basic principles which are the background to this legislation. One is the principle of preservation of capital, and the other is the principle of subordination of claims of members to those of outsiders. We say, when we look at the detail of it, that Section 37 gives effect to those so long as you interpret it as the important words in 37.7, where there are about whether something has been redeemed, as meaning the whole of the process, at least including the payment. Otherwise you get into terrible difficulties. So if we look at Section 37, it starts by, it presents, we say, and as indeed did the learned judge at first instance, a comprehensive code for dealing with redeemable shares. It provides in subsection 1 for the possibility of a company having redeemable shares, then for the possibility, as a result, for a company to purchase its own shares, but then starts to set out the conditions which must apply. Under subsection 3A, they have to be fully paid, that as a condition about redeeming them, which depends upon what's then left in the share capital. Section 37.3c, to which I will return, is simply saying that as to the method of redemption and as the method of purchase of shares, that can be effected in such manner as may be authorised by or pursuant to the company's Articles of Association. It doesn't give a definition of redemption. It is saying no more than that the articles tell you what the manner is in which these things can happen. And alternatively, under D, if the articles don't do it, then the resolution of the directors has to provide for that. Then there are further provisions which are required. And your lordships know from our case, and I will come back and identify the sections, many of these sections and sub-provisions are all talking about payment. And that, we submit, gives a very clear indication that that is a critical matter, that it's one of the things that the redemption is concerned with, and that the consequence of an interpretation which says you can completely ignore whether payment has taken place when it comes to working out the effect. Just seems to be, in our respectful submission, just doesn't give effect to the way the statute is supposed to operate. It makes provisions in relation to, under 4, how the, particularly under subsection 4, how monies are to be dealt with and accounted for. And then, under subsection 7, then deals with the problem, which must have been a very important problem to be dealt with, which is how you deal with payment in the context of an insolvency. And I draw attention to the fact that subsection 7 doesn't just talk about payment being enforced, but the terms of redemption or purchase may be enforced against the company. And it specifically deals with the priority issue under subsection B. That, of course, that provision, subsection 7B, is completely sidestepped in the way that Primeo and the Court of Appeal deal with it. Let me therefore just say a little bit more about priority at this stage. If I can ask your lordships to go to the record at page 1882.
Page 182, did you say?
1882.
I don't think my numbering
Can't be right. No.
This is section 139 and 140. Is
No, my lord, I think I've got, no.
that right? That's my 1882.
No, I've got the wrong reference.
Do you have tabs?
I'm just going to turn it up and find out what it is. I think I'm,
1882 is in the authorities.
yes, I appreciate that, and that's not what I wanted to.
What are we looking at?
We're going to look at the amended points of claim.
Right.
I apologise why I got that reference, I don't know.
Tab 7, is it?
It's tab 7, yes.
Of the record, volume 1.
Of the record.
It's page 181, I don't know why I got. So I'm just,
181, right.
181, just the relief claimed
Yeah.
under G2, that Primeo further claims a declaration as a claim against Herald for payment of the redemption proceeds due in respect to the Primeo shares, which is admissible for proof, and ranks pari passu in the liquidation of Herald with the claims of other unsecured creditors of Herald. So that was the claim that was brought forward. We disputed that, and indeed in the Court of Appeal said it was a strong indicator that their approach was wrong, that it ended up with allowing outsiders to rank pari passu with insiders. In other words, the outsiders ought to have come out first. And that is where the Court of Appeal then came up with or adopted 49G. 49G wasn't the Primeo submission, certainly wasn't a primary submission, because, well, Mr. Smith is saying otherwise, but we can take your lordships to the skeleton arguments, which said that it wasn't any part of their case. So if we look at Primeo's skeleton argument, which is in the record, at tab 19, section
This is a skeleton where? In the Court of Appeal, right? Or,
In the Court of Appeal, yes. Where they say it's no part of the case. What happened was during the course by the time when Mr. Smith came to address the court, as we saw it, the case had changed, and they did then rely on 49G, but previously they'd said,
Which page?
paragraph 26 of the skeleton,
Yes.
page 474. Yes. But they also said they would.
Okay. In the end, we're concerned with the right answer, not what may have been said
No,
wrongly below.
of course, my lord, but what I'm, and it's rather the submission I was sort of starting to make before, if you find that to get to the answer that's desired, you have to go through contortions, that might be an indication, we suggest in this case it is, that actually there's something wrong with your basic submission.
I mean, he deals with it on page 465, in paragraph 7.8, he mentions section 49G.
Yes.
Yep.
Just to make good the submission that I was making, if your lordships would just go to paragraph 16 of the skeleton in the Court of Appeal, that's page 468 of the record.
Yep.
Halfway through that paragraph, they said there's no English authority which holds that a claim by a former member to the redemption proceeds would fall within section 74.2f, which is the equivalent of 49G, and no Cayman authority which holds the same in relation to section 49G of the Companies Law. It has been and remains no part of the appellant's case in these proceedings that such a claim would fall within section 49G.
So what are we getting out of this?
Well,
That the Court of Appeal invented the idea that
No. I'm saying my recollection is that Mr. Smith came back in his oral submissions and relied upon 49G.
I mean, to construe a statute by reference to counsel's contortions does seem rather odd.
Well, your lordship has the point.
The vicissitudes of argument are there, I'm sure, common.
But it's not the only circumstance. But that's, and obviously that's not.
But anyway, you say the case has developed on this.
Of course.
Originally they were saying it wasn't within section 49G, and now they accept it would be.
But it's what leads to getting into 49G because of the recognition, perhaps belatedly, perhaps that doesn't matter to your lordship, recognition belatedly that whatever the answer to this is, it has to be one which treats the claims of ordinary unsecured creditors ahead of the claim of Primeo to claim the redemption proceeds. And I'm not sure I need to take your lordships to the principle that outsiders come out first. We have it in.
Can I just ask a very simple question? And what, therefore, is meant by redemption?
Well, it's not a simple question. It's the question, or rather, the question.
Well, what's your answer to it then?
My answer is redemption, or have been redeemed, means completion of the process of redemption, in particular including payment. The contrast is between saying somebody has served a notice which under the articles has the effect of being
Why the focus on payment? If I purchase something
yes.
on credit, my John Lewis bill will come in a month.
Yes.
I have purchased it, but when the property passes, why isn't the focus on property? And in the case of redemption, why isn't the focus on the moment when the property rights as shareholder are extinguished?
Well, that's obviously the...
But I was going to say, I mean, isn't that in everyday life, you suggest that purchase and redemption inevitably focus attention on payment of the price, but do they? I think in everyday life, I'm not sure they do. I think purchase is when you actually walk away from the shop with the goods. It doesn't matter that you've got an account and you haven't paid yet.
In everyday life, if one of the shareholders in Herald had been asked the question, well, have you redeemed? That person might well say, well, I served a notice, but I haven't redeemed because I've not been paid.
Well, I think you might read the articles, and the articles might say redemption date is on the 1st of December.
But in terms of ordinary language, and of course, my lord, we say that when you construe the section, when you look at its purpose overall, when you look at the problems it gives rise to in terms of priority, it's much more natural to understand it as meaning a process of redemption in ordinary language, which would include critically the question of payment.
But the consequence of that is that the basic object of your argument is to attach the status of shareholders for the purpose of priorities to people who have not been shareholders since the redemption date. I mean, that's the critical fact, isn't it?
Well, in our submission, respectfully, no. The critical factor, what the section is concerned with, is priorities between different people. Yeah. It's people who've actually withdrawn their money. That's one issue. That's why I dealt with that first.
Yes.
But otherwise, people who haven't withdrawn their money.
Why isn't the critical factor whether you are still people with the claimant still has the status of shareholder? Because it's the status of shareholder that causes his priority to be postponed. And if he hasn't got it at the relevant time, why isn't that the critical factor in deciding the issue?
Even Primeo accept that the previous status, on that hypothesis, the previous status of shareholder is relevant.
It may be relevant for some purposes.
Well, it's relevant for the purpose of where the priority is.
Not because they're still shareholders, but under 49G, it's relevant because they once were.
Yes, that's the argument, absolutely. But it's not an irrelevance. Once they've ceased to be a shareholder, that status ceases to have any importance. If your lordships look at section 37 through the way that we would look at it, you see the following. And if your lordships perhaps would take our printed case, first of all, at paragraphs 37 and 38. So first of all, we deal with the capital preservation principle. Plainly concerned, and we cite the passage from Gordon Brown, with not handing back funds except by a lawful distribution of dividend or direction of capital. There can be no controversy in relation to that.
But that submission assumes that you're right, that there hasn't been a redemption.
Yeah.
So it's a rather circular argument.
Well, the opposite argument assumes that there isn't a redemption, that there is a redemption solely by reason of the service of notice and the way the articles operate.
This principle, what is infringed in the principle, the company is actually better off. All it's doing is retaining the price for a limited period, but the shares have been redeemed.
Let me show your lordships just one consequence of this, which is, and I'm going to ask your lordships to do this by taking Reichmuth's printed case.
Capital redemption, the capital preservation rule will be infringed if you distributed money without redeeming, but it's not infringed when it's the other way around, when you redeem and then later.
As a matter of fact, As a matter of fact, before you would on this basis be distributing money which would then not be available for other creditors or for other shareholders before the process of redemption had been complete. And you would then result in reducing the capital merely by reason of the fact that the article said redemption takes place at this point, even though the monies have not come out. May I just show your Lordships one of the consequences of this? If your Lordships will take the Reichmuth printed case.
Yes. Paragraph?
I have to turn up my notes, my Lords, because I wasn't going to get to this point at this stage. It's paragraph 69.
Yes. Thank you. Yes.
And it's worth taking it from paragraph 67.
Thank you.
Where they note, first of all, that the Court of Appeal used section 49G. They then say, with respect rightly, that it's difficult to square that with section 37.7b. As they note, that provides that priority is to be given to all other debts and liabilities other than any due to members of their character as such. So it's difficult, they say, to square with that the idea that the 49G claims are to be treated pari passu with 37.7 claims, because 37.7b seems to say something different. So they say in 68 that 37.7b effectively provides that outside creditors come first, followed by members with a preferred right to income or capital, followed by the claims of an unredeemed member under section 37.7. Claims made under section 49G, i.e. claims made in the character of a member, would seem to rank behind this. And they cite, and we agree with them on this, we cited as well, Fletcher. And we'll come back to that. So that's why they think the result that the Court of Appeal came to, and the route that they came to, and they had to use that route. There was no other way, apparently, of finding that the principle of preservation of capital and the principle that outsiders should come out first could be met. So they go on, Reichmuth goes on to say in 69, it follows from the foregoing that if, as the Court of Appeal found, the December Redeemers' claims fall within 49G, then those claims rank behind any claims falling within section 37.7, behind.
Well, maybe, it isn't being argued apparently, but maybe it throws some doubt on the question whether section 49G applies. Because that does apply only applies to sums due to any member in his character of a member, by way of dividends, profits, or otherwise. Does that really apply when somebody has, if you're wrong and somebody has already redeemed and is simply owed a debt in respect to
well, that's with respect, my Lord,
redemption?
Sorry.
No, I wondered whether there is absolutely clear authority on 49G.
Well, that's begging the question. Where we've got to is, in order to avoid the situation that you end up saying people who are insiders are able to recover pari passu in a winding up, not because they've been paid the money, but in a winding up with outside creditors. You say that, and the only way you can avoid that surprising conclusion, which is inconsistent with the fundamental principle of insolvency law, is by using 49G.
It slightly begs the question whether they are any longer to be regarded as insiders.
Well,
what is the key point which you have to reach in order to be regarded simply as a debtor?
Well, because
supposing one of these people who, contrary to your case, I appreciate, redeemed on the 1st of December, said, I'm prepared to leave the monies with you for longer than 20 days if you want. Why should they not be regarded as an ordinary creditor?
Because the principle behind this, my lords, and that's why the statute talks, for example, in 49G, about accepting their character as a member, the principle behind this is there a distinction to be drawn between those who have been prepared to take the risks of the company by becoming shareholders of other category and those who are simply outside creditors.
But what if you shed those risks by ceasing to be a member of the company?
You haven't shedded the fact that you haven't changed the history.
So you've converted yourself into a creditor.
But, well, my lord, that's what even. Let me show my lords.
What you were going to say, even counsel aren't arguing. But,
Well,
Mr. Gomez, can I just say, it was when I read this, I sort of, all the sort of question marks went up, and I was hoping that sometime during this case we can have on a sheet of paper what everyone is saying is the consequence of their argument in terms of where everyone stands in terms of priorities and why, because Mr. Rabinovich sort of points out this, which seems rather a striking point, but then says he's not actually arguing for it.
well,
I'm not quite sure who is or where everyone else stands on it, but it seems to be quite an important point to sort out
yes.
where 49G comes, and at the moment I'm finding it quite difficult.
As to whether he's arguing it, I read paragraph 69 of his case as quite a coy statement.
yeah, well, that's right. I mean, he sees the incongruity of it, as we all do.
But he ends up by saying, be that as it may, but for the fact that this may be prescribed by section 49G and 37.7, this is not an outcome for which the late redeemers would contend. Well, what's the consequence of that saving? But for the fact that this may be prescribed by section 49G, I can only read it as meaning if that's what section 49G and 37.7 say, then we'll take the benefit of it. Sorry, we don't really want it, but we will. And how can they not?
Yeah, well, I think that is what he's saying, but the question is whether it's right.
We've got to give a coherent meaning to these documents, more or less regardless of what it may or may not be in the interests of particular parties.
Well, my lord, of course. And that's really the point that I'm trying to make. If for a moment your lordships were prepared to take off the redemption is what the articles say, spectacles, and look at the section in the way that we respectfully suggest it should be interpreted, that you haven't redeemed until the money's gone back, none of these problems arise.
I mean, the difficulty about that is that one has the strong feeling that the section or drafters didn't have in mind the incongruities you mentioned now, but I mean, if they had, then no doubt your point is a strong one.
Well, they certainly had in mind, because one can see it in section 37.7, they had in mind we must deal with what happens on an insolvency. And can I just we'll go back to this? I know I'm jumping around a little bit, but it's sort of what happens here. But just to look at the provisos. So 37.7 is saying dealing with the obviously important case of what you do with payment when there is an insolvency, it says you can enforce the terms of redemption if you haven't redeemed, unless, and the two unlesses are, the terms of redemption provide for it to take place at a date later than the date of commencement of the winding up. So the winding up is a cut-off point. Those against the argument I'm putting forward say that doesn't matter, doesn't matter, doesn't matter. And secondly, the second proviso is during the period beginning with the date on which the redemption was to have taken place and ending with the commencement of the winding up of the company, could not have lawfully made a distribution equal in value to the price at which the shares were to be redeemed or purchased. So there's a solvency requirement from the date on which the redemption was to have taken place and ending with the commencement of the winding up. You've got to, during that period. How does that work in this context? It's said simply, oh, well, if under the articles redemption should have taken place, that's enough. And it doesn't matter that the company is in fact insolvent during the period which in reality one is concerned about, which is from the up to the actual winding up of the company. That's one of the consequences of this is precisely the result of the figures that I gave to your lordships before, as to what Primeo will get and what others will get, as illustrative of the problem. There's no, on the argument that redemption simply means what happens under you cease to be a shareholder under the articles, there is no solvency requirement at all now in this section, whereas the legislators thought it important to have a solvency requirement.
Well, there is, no, because surely if in the period defined, that is, between the date on which redemption or purchase was to have taken place and the commencement of the winding up, you couldn't have made a payment, that precludes you giving a notice for, in this case, 1st of December.
Well, no, it doesn't stop you giving the notice. It means you can't enforce the terms of redemption.
Well, it means you can't redeem on the 1st of December, assuming that one gives a notice at some earlier date, triggering the obligation to redeem on the 1st of December. This provision would prevent that redemption occurring on the 1st of December because you didn't have monies, and it would be irrelevant that, in fact, the monies weren't going to be paid until 20 days later. You look at this period and ask, on the redemption date, are they lawfully able to make the distribution?
Well, with due respect, my lord, I respectfully disagree. This is actually about enforcing the terms of redemption or purchase. We've said that's about money. That's the obvious thing that people would be concerned about. They'd be concerned to know, can you get the money in a particular period? If my opponents are right on this, there's nothing in this section which says anything about when payment can be made, or whether it can be made at a time when the company is otherwise insolvent. It would be very odd that the legislature didn't think of that issue. And if your lordships just, in this context, at the same time they're thinking about priority, so go to subsection B. The focus is on payment. There shall be paid in priority to any amount which the company is liable by virtue of paragraph A to pay in respect of any shares, all other debts and liabilities, and so forth. So A is about, according to subsection B, is about liability to make a payment. That's what subsection B says. So the contrast is between a construction which allows for protection as to solvency at a time when the company actually hasn't paid, which one, with respect, would think is an important consideration the legislature would have had in mind. Not just as a bargain between the company and the redeemer as to when in law, when under the contract the redemption takes place, but also when payment takes place. So that would be but if one views the words in this subsection, those words at the beginning have not been redeemed, I'm putting it back in my common language, and I'll take your lordship to some further authority, it's referred to in our case as the meaning of redemption when I get to that. If that means have been paid, you haven't actually redeemed until you've been paid. That's what redemption is all about. Looking at the purchase example may or may not be helpful because I can see that one can visualize having purchased something although payment's not taken place, but that's the principal focus is on redemption. And we say, and as I say, I'll come back to it, on payment. So if your lordships would just perhaps we can go to bundle A2, authorities 2, at tab 50. Actually, let me see. There's an extract from Gore Brown, and unless it's at the next.
50 is Roy Good. 51 is Gore Brown.
Then I'm worried that the. What's it?
Maintenance of capital.
See.
That's a non-point.
Let me come back to that one. I don't waste
Okay.
your lordship's time. But I made the point already, and it's in our case. Shareholders, whether they're redeemable or not, are people who've been prepared to assume risks in relation to the company. They are treated differently when it comes to insolvency from outsiders who haven't assumed those risks. It's those who are prepared, I'm just reading the words again, those who are expected to bear a higher risk than the general body of creditors, such as shareholders. So,
The expression when purchase was to have taken place, purchase involves payment, does it?
purchase does involve payment, yes. But I'm much more concerned, I do submit
I mean, you mustn't just explain why you say it necessarily involves payment.
well, in the context of this,
I see, yes.
in
Right. Sorry, which
we
passage
deal with
were you
that
looking at in
we
this?
deal with that in paragraph 54 of our case.
Yes. Which passage were you looking at in Professor Good's?
Paragraph 817, but
It's not here, 817.
Are we looking at Good or are we looking at Gore Brown? We haven't got 817 of Good.
Yeah.
paragraph 817, where is it? That's who, that's
17 of any of them.
problem's not there. It's paragraph 817, that was my problem. It's good.
Yes, well,
Paragraph 817, I'm sorry to
Very
say.
good, actually.
817, but I don't think we've got it we haven't got it in the volume. That's the problem.
Right, well,
That's why I was.
We're about to be given it, is that right?
I think my lordship right to be given it.
Pass that on. Too many copies.
Oh. Copy.
Right.
yeah.
Well, your lordships have seen it now. And if that accurately states the principle, then the fact that you've ceased to be a shareholder doesn't take away from the fact that historically you were prepared to bear that risk, no doubt in return for reward, and the other body of creditors weren't, and therefore it's reasonable that they should come out ahead of you. And we now seem to accept, well, council seem to accept, that the outside and the Court of Appeal, that the outside creditors should come out first.
Can we go back to 37.7a on page 1870?
My lord.
Where a company is being wound up and at the commencement of the winding up, any of its shares which are
Yes.
or are liable to be redeemed?
Yes. The distinction between those two, our lordship's asking me.
Yes.
Well, that goes back to 37.1, which starts with that distinction.
I know.
which is are to be redeemed or are liable to be redeemed.
Yes, you read it as a short, I think you, in common with at least some of the other parties, read it as a shorthand reference back.
Yes, shorthand reference back.
So we read it, which are to be or are liable to be, are to be redeemed or are liable to be redeemed.
So, in other words, are brackets or are liable, close brackets.
Yes.
But, my Lord, and if I may say so, Natixis make this point, and it's a good one in our respectful submission. The classic, and it maybe there are other examples, but the classic example of a case where the words are to be redeemed would apply is in relation to a fixed term redemption. So you've bought December redeemable shares, which under the terms are to be redeemed on the 1st of December. The liable to be redeemed would be one such as in this case, where there is an option either in the company or in the shareholder to redeem by service of a notice or whatever else. And I'm going to make, if your lordships have that in mind, and I'm going to, my friend Mr. Rutten doesn't mind, I'm going to make this point that he makes in his case. If you take the case of these words are to be redeemed relates to a fixed term redemption, how does this subsection work at all? Either the fixed term gives you a date which is after the date of the winding up, in which case, under subsection 1, proviso 1, you can't enforce the terms, because proviso 1 doesn't allow you to enforce the terms if the redemption is to take place at a date later than the date of the commencement of the winding up. So in the example, this is the terms of the fixed term redemption are your shares will be redeemed on the 31st of December. Winding up takes place on the 15th of December. You cannot recover under section 37.7 because the terms of redemption, and there can be no argument, we're not arguing what redemption means under this example, on the hypothesis advanced by opponents, the redemption would be the 31st of December. It's after the date of the commencement of the winding up. Therefore, section 37.7 A will not work. There's only one other possibility, which is that the term of the provision for redemption is before the date of the winding up, in which case proviso 1 doesn't apply. But if the Court of Appeal are right, and if Mr. Smith is right, section 37.7a will not work either. It will not work either because there will, on that hypothesis, have been a redemption before the winding up, because it will happen at the moment that, under the articles, it takes place, in which case 37.7a cannot apply, because it will not be the case of someone who has shares which are to be redeemed and which have not been redeemed. Because on their argument, it will have been redeemed. They will have been redeemed. So there's no example in which section 37.7a actually does any useful work. And which is a point I've been making, and there's nothing else in the section which tells you how to deal with solvency, how to deal with priority, because it's only dealt with in the circumstances where 37.7a applies. 37.7b only deals with priority as against the obligation under 37.7a. The point I'm making is, on the face of it, section 37 appears to be a code, as Mr. Justice Andrew Jones said, and yet, on the construction put forward by my opponents, this critically important provision has no work to do. Contrast the submission we make as to its construction. If redeemed means you've got your money back, I've redeemed my shares, I've got my money back, then 3770 works perfectly well. Then you read it as saying, if there are shares to be redeemed back on 31st of December, fixed term, they've not been redeemed, no, because I haven't been paid, in my example, haven't been paid. You can then enforce the terms subject to Proviso 1 and indeed Proviso 2. But if the term of if the term for the date for redemption is the 15th of December before the commencement of the winding up, if you've been paid and it's redeemed in that sense, well then you don't need subsection 7A because there's nothing left to enforce. But you'll still be caught by the proviso if, in fact, you haven't been paid.
You're really reading redeemed and purchased in this context as completion of the exercise.
Well, at least payment.
Yes.
At least payment. I'm not excluding there may be some other. Yes, yes.
The draftsman has differentiated in the earlier subsections between, or some of them, between payment and redemption, hasn't he? 6A, a payment out of capital for the redemption, for example.
Well, what we say is that he refers on many occasions to payment, and that gives the flavour to what this is actually dealing with.
It cuts both ways because he distinguishes between payment and redemption.
Well,
whereas you say payment is part of redemption.
He's dealing with something different.
Yeah, I see that.
I mean, just take, for example, a little f.
Yeah.
5F, where the proceeds of a fresh issue are applied by a company in making any redemption. Well, that only works in circumstances where the redemption in that case involves actual payment.
Yes.
We deal with this in our printed case at paragraph 40 and following. Perhaps I can just take my lords to that.
Yep. Yes.
So that is our submission, as my lords summarise it to me. Subsection, show the word redemption is used to signify the completion of the whole process of redemption, including payment. And unsurprisingly, the position is the same in the case of the parallel provisions related to purchase by a company of its own shares. And then we identify the provisions which do that. So little e talks about the premium, 3e talks about the premium payable on redemption. 3f again is focusing on payment. Shares may be redeemed or purchased out of profits. Little b, if the shares are redeemed or purchased wholly or partly out of the proceeds of a fresh issue. Again, it's the focus is on payment. Little d, the capital payment for shares redeemed or purchased. And then little f, which we looked at a moment ago, where the proceeds are applied by a company in making any redemption or purchase, and 37.6. A payment out of capital by a company for the redemption. Now, the focus, we say, is time and again is on payment, and that is understandable because what you're concerned about is not the legality of who is and who isn't a shareholder. You're concerned with monies going out of the company. You're concerned with monies going out of the company for two reasons. Firstly, because but for statutory authorization, you couldn't return capital. You couldn't historically have redeemable shares. It's only by reason of Section 37 saying you can. So you're concerned with preservation of capital, but you're also concerned what I think is called by Mr. Smith the cardinal rule that outsiders come out before insiders.
Can we just go back to your argument that Proviso 1 would never have any effect in relation to a fixed date redemption?
Yes.
There are 6A, which we were looking at, surely means that a company could fail to honour a fixed date redemption because it didn't have sufficient capital. It wouldn't be lawful for it to honour the fixed date redemption. And isn't that a situation where you could have shares which were to be redeemed by agreement, but which where the company has failed to honour the agreement because it's no longer lawful for it to honour it?
Of course, that's not dealing with the critically important area which we are concerned with, which is in the context of a liquidation. It's only subsection 7 that does that. The rest is to do, and so all sorts of things.
No, but I mean, we're talking by definition about a period before the commencement of the winding up, and the question is that you pose: how could you have a fixed date redemption occurring before the commencement of the winding up, where if redemption simply means the agreement to redeem without, or the redemption of the articles without payment, without the Proviso 1 applying, I think, and you were using that as an argument to say that redemption includes payment. But is that right? I mean, if you have a fixed date redemption before the commencement of the winding up, the company could fail to honour it.
Yes.
Yeah.
Yes.
Well, that's isn't that a situation then when the terms of redemption did provide for redemption to take place before the commencement of the winding up, but it didn't take place, not because it wasn't redemption or wouldn't have been redemption, but because it's barred by other provisions of this clause.
I think in the example my Lord's given, perhaps I misunderstood the example, the thing which didn't happen was payment.
No, the thing which didn't happen was redemption. You're not allowed to. I see. Well, you say we ought to, under subsection 6. You're right. It would be the payment which for the redemption which wasn't lawful. But I mean, presumably you could have situations where the redemption itself wasn't lawful, couldn't you?
Or where it was subject to a procedural condition precedent,
Yes.
such as the requirement of director's consent. I mean, this has to cater for a variety of possible provisions that might reasonably be expected to be found in articles.
I'm going to, again, if he doesn't mind, just make sure that the point is that I've made the point properly. I'm going to ask your Lordship just to look at paragraph 21 of my learned friend Mr. Atherton's skeleton, printed case, I should say.
Yep.
Find it.
Yes, I mean, actually, I think it's quoted in your case, but it's Gower, edited by Professors Davies and Worthington, seems to postulate situations where you could have a fixed agreement to redeem, but as my Lord said, and as I was putting, the company fails to perform for one or various reasons.
Well, I think there's a couple of points there, but just make this and then go back to what I wanted to say. We say that the only work that has been found for Proviso 1 to do on their construction of have or have not been redeemed is to say some other requirement was there which hadn't been fulfilled.
Yes.
Saying, but there's no examples been identified of that. It's speculative that would be the case, and it certainly isn't the case here, nor our submission would it normally be the case. And one can imagine anything, I suppose. But it's much more natural to think that what subsection Proviso 1 is dealing with is a case where you've got a winding up, you've not been paid out before the winding up, and the date for payment is after the winding up. Okay, shutters have come down. That just it all works. It all makes sense. And you don't have to worry about priorities then, which is what we will come to, because B tells you what the priority is. But my lords, recall, please, that although section 37(7)(b appears to deal with priority, as you would expect it would, it doesn't apply unless you're talking about a payment which the company is liable by virtue of paragraph A to pay. That means, that's why this doesn't apply according to Primeo, because they're outside section 37(7), because they don't fall within 37(7)(a). So, developing that 37(7)(a) only applies if you have not been redeemed at the commencement of the winding up. On the argument advanced by Primeo, you have been redeemed at the commencement of the winding up if the articles say you will be redeemed on giving notice 2 days later, 20 days later, 20 years later, or on a fixed term. But if you don't have that, on that construction, you never get into A, and therefore you can never get into B, because B is only concerned with payments by virtue of paragraph A. That's why the only way that could be found to give effect to the principle that outsiders should come out first was to use 49G. And it is.
Is it relevant to look at all at the actual articles?
Well, of course, for certain purposes it is. But when it comes to what is meant by have not been redeemed, importantly, the statute never says, it never gives a definition of redemption, which is perhaps unhelpful or doesn't take us any further, but it never says redeemed in accordance with the provisions in the articles. Now, for other purposes, you'd have to have regard. For example, in the strategic turnaround case, perhaps we should just look at that, because, as I've suggested, this may have coloured quite a lot. Your Lordships have got strategic turnaround in the authorities bundle.
Yep,
At tab 4.
yes. I think it's tab 5, actually.
I'm sorry, tab 5. Yes, I obscured the number. I apologise. My Lord Mance giving the judgment of the board, and identifies in paragraph 1 that the issue was whether the petition was an abuse of the process. That depended on whether at the date of its issue the appellant was a current creditor with standing to issue it, or at best only a prospective creditor, in which case it would have no such standing. And if we go on to paragraph 16, the question at issue was whether, upon the construction of the appellant's articles, read with such other documents may be incorporated or referred to therein, go back to paragraph 15, whether the company had power to suspend the payment of redemption proceeds after the redemption date but before payment of those proceeds. It was an issue which turned on what the articles provided and what were the rights under the articles. It doesn't turn at all on what is the true construction of section 37(7) or anything of that sort. And one sees that at paragraph 20, and no doubt used against me, but can't be actually on what's said. Paragraph 20, my Lord writes, that the focus of these provisions is on the redemption date by reference to which the redemption price payable is crystallised, from which the price is deemed to be a liability of the respondent. The remittance of the redemption proceeds is treated as a matter of supplementary procedure, though it may be refused on, in particular, money laundering grounds. But both stages may be said to be part of a continuing process, but it doesn't follow that redemption within the meaning of Articles 55 and 32 only occurs at the conclusion of that whole process. Now, whether it does or does not occur at the conclusion of that whole process for the purpose of the articles will obviously be determined by the articles. Whether redemption for the purposes of the statute occurs at the end of that process is a question for construction of the statute. And as we say in our case, one assumes that the meaning to be given to redemption or have been redeemed is an autonomous meaning, because this has to apply in many different cases with many different articles. And there's nothing in the statute which says you take the process under.
I mean, can you separate the concept of redemption under the articles from the statutory concept? I think you focus on payment, but one focuses on the passing of property. That must be defined by the articles, mustn't it? The moment at which the shares are extinguished is inevitably defined by the articles.
Yes, so that may be subject to reversal. And we make this point, and let me just, so that your lordships know what we say about this. We say that redemption is a process. For the purposes of the statute, redemption is a process. In this case, Primeo did not complete the process. It didn't complete the process because payment has not been made. Where does that leave them? It leaves them not having succeeded in redeeming. And we say that that throws them, not throws them back, but puts them back in the position of being a shareholder, so far as claiming in the liquidation is concerned, along with other people in the same position.
It's a kind of deeming, is it? It's deemed to be a shareholder, although actually not.
Well, they can be. Indeed, there's a wide power to rectify the register. So if they have failed to convert themselves, but because...
But they have. I mean, what is wrong with the extinction which is provided by the articles of their proprietary interest? On what basis is it reversed simply because they haven't been paid?
Well, because there needs to be a basis under which there can be some way of if there's a surplus in the liquidation, of paying them. It has to be one which doesn't allow them to be paid before others, which doesn't give them priority over any other unsecured creditor or over any other...
No, but I think the point's slightly different. Do you accept that the shares have been validly cancelled, even if your argument's right?
They're not cancelled under the articles.
Well, whatever it is, do you accept they are no more, so far as they are not shareholders?
Well, it's quite important, my lord, because...
Well, it is, but that's why I'm asking you.
Well, the point I'm making, may I just make it?
Yeah.
Because when it comes, and because this may be what my lord has in mind, when it comes to other provisions in section 37, which talk about, for example, cancellation of the shares, this is a point that's relied upon particularly in the Court of Appeal below. Yeah. One has to apply the same meaning to redemption in that section as we're putting forward for 3777.
Do you say they're still shareholders?
Yes, they are still shareholders if they haven't succeeded in converting. That's the only status they can have.
You've got to say that, haven't you? I mean, that's the critical proposition.
I beg my lord's pardon.
That is the question: whether somebody is a shareholder. Can that ever be decided otherwise than by reference to the articles?
But in the context of a winding up, which is what we're concerned with, the question that arises is, can they be paid, and if so, when and in priority, or subject to whom?
According to the articles, upon redemption, I mean, we haven't looked at the articles yet, but upon redemption, they cease to be entitled to any rights in respect of the shares, excepting a right to receive a dividend which has been declared thereof prior to such redemption being effected. And accordingly, their names should be removed from the register of shareholders with respect thereto, and the share redeemed shall be available for reissue, and until reissue shall form part of the unissued capital of the company. Now, you have to say that all that is in some way reversed, don't you?
I'm saying it's subject to being reversed because they haven't completed the process of conversion.
But they have under the articles.
But they
The
have.
articles
Paragraph 16 of the Statement of Facts records the agreement, I thought, that they were redeemed within the meaning of the articles.
But within the meaning of the articles is the critical point, my lord.
Right.
Yes, but I mean, that's what you're being asked. I mean,
Well-
they clearly, you know, as I understood it to be common ground that they were redeemed within the meaning of the articles.
Yes.
And removed from the register.
Yes.
So your point has to be that section 37 involves a different meaning to the articles.
Yes. I think I made that very clear. I don't shy away from that for one moment.
So
We've said that throughout.
They're not members on any view of the company.
They've got, there's no, I'm saying is there's no, the question doesn't actually,
It may not, I'm not saying this is a point against you, right? I'm just trying to work out where we are. And as I understand it,
so,
there's nothing in the articles
26.
and in the fact that the shares have been treated as redeemed for that purpose.
can I,
On what basis could you reverse the removal of a shareholder from the register if the removal was required by the terms of the article?
well, let me take you to the suggestion as to how it's done. If your lordships will take the authorities bundle at tab 53.
Tab 33.
53.
53.
Gower. We cite this in our, at paragraph 1328, we cite this in our case.
Paragraph 13.
Paragraph 1328, which is the...
Thank you. Yes, I have it. Yeah.
And it's really the passage on page 1934 of the record.
Thank you.
It starts with the words, a second issue. A second issue which arises is the position if the company goes into liquidation before the shares have been redeemed or repurchased. The Act provides that the terms of redemption or purchase may be enforced against the company in winding up, but subject to the restriction on specific performance noted above. However, the shareholder will gain little or nothing by enforcing the contract if the winding up is an insolvent liquidation, since the member is a deferred creditor. Any claim in respect to the purchase price is postponed to the claims of all other creditors, and indeed to those of other shareholders whose shares carry rights, whether to capital income, which are preferred to the rights as to capital of the shares to be redeemed or purchased. Moreover, even this limited right may not be enforced in liquidation if the terms of redemption provide for performance to take place at a date later than that of the commencement of the winding up, or if during the period beginning with the date when redemption or purchase was to take place and ending with the commencement of the winding up. If the company did not have distributable profits equal in value to the redemption or purchase price. In this case, this is where it gets to, in this case, it appears the member is treated in the winding up as if there were no obligations on the company to redeem or purchase the shares, and as if he or she was still a member of the company. That's what we say the situation is if they've not succeeded in completing the process of redemption.
Yes. So, I mean, if they have succeeded in completing the process of redemption, that doesn't apply. That's the... it's back to the argument.
Well, it gets back to the argument of what is meant by completion of the process of redemption.
In a sense, I don't know if this is a fair point, but Section 37 seems to proceed on the assumption that payment and redemption will occur simultaneously. That what happened in this case won't happen. I mean, if you look at Section 37(4)(a) on page 1868, where under this section shares of a company are redeemed or purchased wholly out of either or both the company's profits and so on, presumably it would be agreed that this provision would apply even if the payment occurs after what, assuming against you, is redemption. In other words, have been redeemed. The point I'm getting at is that 4A is phrased on the assumption that the redemption and payment are made at the same time.
Which is, of course, what I say the position is.
Well,
because of the meaning of redemption.
No, you don't actually. What you say is that redemption is postponed by some sort of condition subsequent.
I mean, what you can say is that redemption, I would have thought that in a case where, on the facts of this case, the redemption is treated as having taken place under the articles, but actually the purchase money hasn't been paid, but it is going to be paid out of the company's profits, 4A would still apply. But actually 4A and the case against you would read, have been redeemed.
Well, I'm not sure if this is an answer to my Lord's question. We say two things. Obviously, we say that throughout the section, redeemed means the same thing and is not limited, does not mean as under the articles. The articles obviously have a relevance to it, but the process has, we submit, to be completed. And if it is completed, none of this problem...
I understand that, yeah. What I'm concerned with is how the draftsman or woman, or how one puts it, how the section is expressed. Now, you would say redemption and payment treated as the same thing. What I've got in mind is that redemption, it seems to be assumed that redemption will be taking place when payment is made, or payment is made.
Yes.
Yes. That is simply the draftsman's assumption. I'm not quite sure where it goes, but I presume that 4A would apply, and everyone would agree it would apply, even where redemption, in the sense the Court of Appeal held it meant, occurs before the payment out of the company's profits. So let's say, on the facts of this case, the payment is made out of the company's profits, 4A would apply.
Well, at the moment, I'm having difficulty in seeing what difference that makes because
Well, that's what I was going to ask you, but technically they are not redeemed in the present out of the company's profits. On the case against you, they have been redeemed, and they will be paid for out of the company's profits.
Well, that is the case against me, yes. Yeah. But if my Lord is putting to me, look, reading the section, it looks as if it is assumed that redemption does not take place unless payment takes place, then that helps my argument as to what is meant in the statute by redemption.
That's sort of the point I'm getting at.
So,
the other bit we were looking at Culross.
yes.
I thought one might look at, there is something about Section 37. I think it suggested that nothing was said, but...
no, I didn't say that.
It may be by unhelpful because it seems to be based on something which was uncontroversial. Anyway, paragraph 8 on page 1099.
Yes, well, I hope I didn't say nothing said about it. What I was saying is that Culross doesn't proceed on the basis of trying to identify what the meaning of redemption in Section 37 is. I mean, my Lord does say that the manner in which any redemption may be effected must be authorised by or pursuant to the Articles of Association. I think I said that before. I fully accept that. It must be authorised by the Articles. That's one of the conditions. That's one of the conditions that Section 37 sets. But what that doesn't mean is that redemption is the same for the purposes of the statute as what it is under the Articles.
I think the point I'm putting you under subsection 4A is, and generally, if it's right that the section envisages redemption and payment taking place at the same time, it may be that you can argue that the draftsman was therefore envisaging that any payment was caught because he was envisaging it would occur before redemption. And therefore, it could be possibly argued, I'm feeling my way towards the point, there may be nothing in it, that therefore any payment for the redemption is intended to be caught.
Well, my Lord, that the assumption was that there wouldn't be a redemption unless there was a payment, and therefore it wouldn't be a redemption. Don't mean under the Articles, and that's the problem, but under the statute it wouldn't be redeemed. This is a statute which will apply to all manner of articles.
Yes, but the other view is that it simply doesn't cover a case such as where payment is made after redemption, and it simply is a gap.
But that's not dealing with the case that we're... Perhaps, Your Lordship, will just give me a moment. Well, Your Lordship knows that what we say is important is what subsection 7, but I know Your Lordship says we've still got to look at the other sections. I understand and accept that. My Lord, Mr. Justice Andrew Jones, at first instance, described this, we would submit rightly, as a complete code. It covers everything, and we set this out in our case. It covers authorization, it covers terms, it covers insolvency, it covers priority, it covers payment. And so one has to do, when one sees it as a code, one has to do the best one can to interpret what it all means. If, in our submission, one takes the concept of redemption, which the risk of being over repetition is not defined as meaning always the same as is under the articles, then everything can work. Whereas on what has happened is interpreting it in the way that it's interpreted by the Court of Appeal, things don't work.
I mean, the strongest point in your favour, arguably, is that, as what I was going on before, is that if this is not within the code that you would say is a complete code of Section 37, it really, we're searching around as to how to deal with priorities. And in a case like this, which is why I'm very keen to find out at some stage where everyone stands on that. Because if it's not 49G, then, what is it? And whereas on your view, the great strength of it, you would expect it all to be caught up within a single code, which provides for this sort of any situation where the money hasn't been paid out before the clamp comes down. That seems to be your main point, but of course there's a limit to which you're allowed to distort the language of the statute to sort of deal with it.
Well, my Lord, with respect, we're not distorting the language of the statute at all. The statute never says redeemed under the articles. It uses an autonomous expression, which would be applicable in the case of any sets of articles. And I'll take Your Lordship now to what's been said. It's not...
yes, I mean, your point is whatever the articles say, redemption for the statute is a process which includes payment.
It's a process which includes payment, and that makes sense of everything in the statute, whereas treating it as simply what's under the articles doesn't do that.
And 4A is consistent with that.
Yes. And just if I may, I have to come back to this, but it's not just that one searches for a way of dealing with priorities. It's worse than that, because that what I've described, and he'll have to forgive me for repeating it, as a coy statement by my learned friend Mr. Rabinowitz, is actually saying that the late redeemers take in priority to those who admittedly are operating under 37.7. That means Primeo. So instead of the people, so those are people, they're not the people who tried to redeem earliest, they're actually the ones who redeemed later. But they take priority according to this theory, and it's, though he says, well, it's this interesting statement that he doesn't contend for it unless that's what the law requires, in which case no doubt they'll be very happy to take the benefit of it, reluctantly shaking their heads in wonder, but still taking it. But that's not just finding a way of dealing with priorities. It actually means that the way that the Court of Appeal dealt with it results apparently not just in the priority, having to find something the priority, it results in the priority being actually distorted. So someone who applied to redeem later didn't do it before the balloon went up. or sorry, not so much that, but didn't do it in time to be able to have a valuation date, and therefore couldn't actually claim a voucher, that person will come out ahead of the Primeos. That is such an extraordinary result. It makes one really question, how can it be? And this is why why the issue about priority was important in the Court of Appeal. So what the Court of Appeal did, and perhaps we should take my lords to the judgment. I should try and show you, your lordships, where we say that the Court of Appeal respectfully went wrong. So, in the judgment of the Court of Appeal, which your lordships have at tab 21 of the, at paragraph 55, there's a passage which starts at paragraph 53. So it's,
sorry, which bundle is it in?
this is in the, it's tab 21 in the record.
Yeah.
Paragraph 53. Justice of Appeal Field says the claims would rank behind the claim of Herald's ordinary creditors, and then notes that it had been submitted by Primeo that wasn't the case, that they ranked pari passu, and he rejects that argument. Then says at 54, the claimant's claims would rank ahead of their entitlement of other Herald shareholders be paid sums due to them in their capacity of members. And then 55, in terms of ranking, the outcome of the postulated claims would therefore be the same as the outcome of a successful claim under 37(7)(a), which puts paid to the appellant's contention that it cannot have been intended that shareholders of shares redeemed under the article without payment could claim in the company's liquidation otherwise than under section 37(7)(a), because the outcome of such a claim would see the claimant ranking pari passu with the outside creditors. And that's, with respect, simply wrong. You can't equate the outcome of a claim under 49G with a successful claim under 37(7)(a. And we saw that because of the reference in 49G other than in the character of a member. And that's why in the Reichmuth skeleton, written case, apologise, they said, Mr. Rabinovich says, it's very difficult to square that with actually the wording. It's as good a place to look at the wording as any. Which is paragraph 67 of Malone and Friends' printed case.
Of Primeo's printed case?
No, Reichmuth's printed case. Just because it's convenient to...
This is the thing we looked at before.
Yes, indeed. But
57, did you say?
67.
67.
It is what we looked at before. So the short position, I'm not sure anybody contends, and Mr. Smith will correct me, anyone contends that the Court of Appeal were right to treat a claim under 49G as equated with a successful claim under 37(7). And that's because claims against the company under 37(7)(a, there is priority given to all other debts and liabilities of the company other than any due to members in their character as such.
Yes, I noticed that Mr. Justice Edward Bannister held the contrary in a case which the Court of Appeal was disagreeing with.
Yes.
Paragraph 53, yeah.
Yes.
So we'll have to look at that.
Yeah, there's an issue about BVI because of the difference
Yes,
in company
right.
law. Your lordships, I think, are conscious of that. But what Mr. Rabinovich rightly says in 68 on the face of it is that 37(7)(b) effectively provides that outside creditors come first, followed by members with a preferred right to income, followed by the claims of an unredeemed member under section 37(7). Claims made under section 49G, i.e. claims made in the character of a member, would seem to rank behind this. And there is further authority for that, which we've got in our printed case, and I'll try and come to them conscious of time, including Fletcher. So on the face of it,
So which claims is the Court of Appeal talking about in paragraph 55? What are the postulated claims?
talking about Primeo's claims,
Primeo's claims, just Primeo.
but saying that they rank alongside
Yeah.
37(7), and that's, because we said you need 37(7) to get the priority right.
So that's just a basic error, you say, in treating 49G and 37 as leading to the same priority.
Well, it is an error, but it has a very significant consequence, because it means either you end up saying that they rank behind, or they end up ranking above, which is very surprising, because that then means that the people who tried to redeem later and certainly didn't complete it do better than those who did it in time. This doesn't arise if you interpret
Understand?
redemption under the statute as meaning including payment.
And this has nothing to do with the particular articles in this case. You say it's a general point.
Yes.
Understand?
But if you treat redemption as meaning including payment, it doesn't arise, because then you get into 37(7)(a, and then the priority is set by 37(7)(b). My attention is being directed to, by Mr. Tregear, to paragraph 30 of the Natixis printed case.
Sorry, paragraph what?
30 of the Natixis.
30 or 30?
30.
30, yeah.
The whole of it.
And paragraph 30 sub 3, it is being pointed out, and this may, that the situation that has arisen in which redemption could take place pursuant to the Articles of Company before payment could not have arisen under the English, because at that stage,
Yes.
terms of redemption must provide for payment on redemption. Well, that may give rise to some of the, including the point my Lord put to me. But the fact is, we have to deal with this complete code as it's come out. And the fundamental submission is that, looking at the language, looking at the consequences, it is better, it is more natural, it gives more effect to make this a coherent statute, and one which is gives proper effect to preservation of capital and to priority between different people, than treating it as simply determined by what the particular articles of the case may say. Now, so far as the meaning of redemption is concerned, we identify and we refer in our case. Where's our referral? in our printed case, I mean, maybe we can do it enough, we identify at paragraph 4, paragraphs 45 and 46 of our printed case. So we make the point in 44 that if it's a complete code, it needs to deal with not just a moment in time when redemption takes effect under the particular articles. And then we say at 45 there's no statutory definition of the word redemption. And given that it may differ widely from company to company, it's submitted that the meaning should be considered to be an autonomous concept for the purpose of the law, and for Section 37 in particular. And on that basis, it should be given its ordinary and natural meaning of a process for the buying back of shares which ends with payment. And we refer to a couple of things. We refer to the decision of Arrowfield Group Limited, which you've got at A20, but it may be sufficient to read it from what we've got in the printed case. Quoting from Ford and Austin's Principles of Corporations Law, the judge said, it's said by those authors that redeemable preference shares are a form of temporary shareholding which, like debt finance, because the amount invested may have to be repaid before liquidation. The definition of redeemable preference is that a redeemable preference is a preference share liable to be redeemed. This is hardly of much assistance. The ordinary meaning of redemption in these circumstances, that is to say, other than the theological one, is to buy back or pay off. See Jowett. The Macquarie Dictionary also refers to recover something pledged or mortgaged.
This is in context of an entirely different issue, isn't it? The issue is whether you could redeem by substituting within the Australian statute one type of share for another.
Yes, but even so, we're looking for what assistance can be given to the board in relation to the meaning of this.
Well, I was suggesting perhaps there wasn't a huge amount of assistance.
Well,
I mean, he's not focusing on the present point as to whether it's actually.
Maybe paragraph 47 is a better.
Beg my pardon?
Maybe paragraph 47 is a clearer point.
Yes, I'm grateful. So, Mr. Justice Graham saying that in respect to the redemption of matters such as shares, the general meaning of redemption is to pay them off. That is, in our submission, it is what the ordinary meaning would mean. And I know, my lords, imagine shareholders who carefully study the Articles of Association to see whether they've been redeemed or not, but I would respectfully suggest they're much more likely to adopt the approach of, I've been redeemed when I've been paid off. And it's of no assistance to me whatsoever to discover that they've still got all my money. I would not regard that as being redeemed, and there's no reason why that shouldn't be the way it's been approached in the statute. You're not redeemed unless you're paid off. All the references to payment in the statute make that sense. And actually the same is true of purchase or sale, and we deal with that in paragraph 54, 58 of our printed case.
It depends on the fact. I mean, if you were to say, right, agree with the company that it will redeem your shares for £100 to be paid today, and £100 to be paid 2 years after redemption, and the company, you then hand back the shares, get your £100, and the shares are then recorded as redeemed. I would have thought, as a matter of ordinary language, they were redeemed. The fact that there's a part payment yet to be made. Well, as a matter of ordinary language, most people would say the shares have been redeemed.
Well, part payment adds an additional complication.
Well, it does, but it may do. But all I'm saying is that I've called it part payment, but delayed payment. The shares have still been, in ordinary language, redeemed. I mean, I think what you can say is that the word is capable of covering completion of the redemption in terms of full payment. But
it's a process, my lord.
Well, it can be, but it's... Let's say there's nothing to stop the company agreeing that you will pay later and they will redeem the shares and reissue them to somebody else, is there? I think, conceptually wrong.
Come on to the reissue in a moment. But
But if it did that, it'd be very hard to argue that simply because there's a delayed payment that you're going to receive later, that the shares haven't been redeemed.
there
As a
are
matter of ordinary
two...
language.
So sorry, my lords.
As a matter of ordinary language.
There are two potential meanings for what the statute says.
Exactly.
One is that it means simply, if it's happened under the articles, that's an end of it. And the other is that, no, it means completion of the process of redemption, including payment. And when it comes to interpret which is the correct interpretation, we say the language helps, so many different references to payment. We say that the consequences help because you do not have a coherent scheme if it means what Primeo say, and it leads into all sorts of difficulties. Let's just, if we go back to the Court of Appeal judgment, please, which I didn't sort of complete, asking the Lordships to look at it. There are 2 points which the Court of Appeal relied upon as being clear indications of the construction they reach, which actually don't do anything of the sort. They simply beg the question in my very respectful submission. So this is... if your Lordships would kindly go to paragraphs 47 to 49. Now there's there is an issue which the Lordships, I think, now appreciate, because nobody appreciated that Section 37, capital A, didn't actually apply at the time. It's come in subsequently, and we've dealt with this by sending a letter to the court. But just assume it's, and therefore the arguments that have been advanced by the Court of Appeal don't actually work. I should deal with this properly, actually. I'll take that on my own question. First of all, Justice of Appeal Field says that when redeemable shares are redeemed, they're not cancelled but go into the Treasury, i.e. as Treasury shares, and become available for reissue as a shareholder. That's actually not correct, because the Treasury shares don't become available for reissue under Herald's articles. Now, contrary to Justice of Appeal Field's understanding, they don't form part unissued. They don't form part of the unissued share capital available for reissue, but are distinctly classified and entered on the register of members as Treasury shares held by the company pursuant to the terms of Section 37A as a distinct class of shares. They can be transferred to a third party, but they're not capable of being reissued. They are issued shares, which are then registered in the name of the company. And the articles, if one looks at them, don't actually permit the issue of any shares other than participating non-voting shares. But even without those errors, if one looks at what...
Which article are we looking at?
Looking at Article 23. Should we look at that?
Oh, yes, right, okay.
We need to look at Article 23 and also Article, the definition of share. So the articles are in tab 6B of the record. So at page 71 of the record, share is defined as a participating non-voting share in the capital of the company. Article 16 deals with allotment. Article 16 deals with allotment and issues at the price, and then Article 17 says that only participating non-voting shares shall be allotted or issued. Article 20, the redemption provisions only apply to those shares. And then Article 23 deals with what happens on redemption. Yeah, I'm sure I don't need to continue to say redemption under the articles. Now, what Mr. Justice of Appeal Field said, he says in paragraph 47, so when redeemable shares are redeemed, they are not cancelled but go into the Treasury and become available for reissue to a new shareholder. Which he says is a clear point to the conclusion that it's when the redeemer ceases to be a shareholder that there is redemption for the purposes of the whole of Section 37, including subsection 7A, and not only when the redemption proceeds are paid. But that is by using that definition of redemption for the statute. So we go back to Section 37 itself. Apologise, my 2 seconds. Well, I'm sorry, I'm going to take it from the authorities bundle. 43. Yes. So if we look at 37 capital A, that's at page 1871 of the record.
Yep.
I thought, 37A is wrongly regarded as relevant because it wasn't enforced. Is that right?
That's right, yes.
Well, what's wrong, though, with Justice of Appeal's statement in paragraph 47, if one applies it to what was in force and to Article 23? They did become available for reissue to a new shareholder, didn't they, under the Articles? On redemption, defined by the Articles as 1st of December.
.3 G is what I think this is what the learned Justice of Appeal had in mind. 37A.
I'm sure 37A, the references are all wrong, but I just wonder whether, if you make allowances for that, in fact, the same result doesn't apply if one looks at the right things.
Well, can I take it by asking your lordships to go to 48 and 49 in the judgment? Because that's a focus on the statute, and this is where the alleged nonsensical outcome comes from. Obviously a strong statement if that's true. And that follows from the words that when shares are redeemed, they shall be cancelled. Because he's saying if they've already been cancelled, which they will have been under 37.3G, if they've been redeemed under the articles. Well, that depends upon what's meant by redemption in 37.3G. That's the problem.
Yeah.
And if you interpret it as not having been redeemed for the purpose of 37.3G, because that's not what redemption means, this point doesn't arise.
And you say none of the references in section 37.3 to the company's own articles affect this issue?
I do. They don't affect the
They're concerned with procedure rather than substance.
well, they're concerned with the, particularly 37.3C is requiring that the manner of redemption should be set out in the
Right.
articles.
So I'm saying it's procedure.
Yeah, and then in that sense, my lord, yes, I agree with I respect with that. But the points that are made, the two clear indications, only arise as a result of interpreting the section
Yeah.
in the way it ultimately it was. But that
You're
is
ultimately saying that in that passage he confuses redemption under the statute and redemption under the article.
yes, yes.
And they don't necessarily have to mean the same thing. Yeah.
But as the question at issue is which is the correct meaning, then you can't apply one meaning to
Right.
it and then say, therefore, it's nonsensical if it doesn't have that meaning, because it's obviously, you've already begged the question in the way you've posed it. I'm just trying to see. We try and bring some of that together, and I may have done it in the course of what I've said already, as often happens, and then I apologise for the repetition. But your lordships have the points. Section 37 is a complete code from issuance to liquidation. Traditionally, companies prohibited from buying their own shares or returning capital unless specifically sanctioned. And that doesn't just mean the fact of sanctioning, it also means the terms on which it takes place. And Section 37 is a scheme for dealing with that. Then it provides a comprehensive code for redemption of its shares from the very beginning to the end, and deals importantly with priority. And it would be very odd, we submit, if setting out that code it had been left incomplete, so that the claim for redemption proceeds of Primeo and the December redeemers should fall outside its scope. It's an obvious thing to want to deal with. What if somebody hasn't been paid before the winding up shutter starts to come down? Surely you deal with that. But on the case that's put forward by my opponents, it's not. And then it would be even odder if when Section 37.7 specifically deals with the priority of payment in a liquidation, to find that it actually has no application, to find that it's dealt with by another section altogether, Section 49G, which says nothing about redemption, doesn't expressly deal with redemption at all. And then I just want to these difficulties don't arise if, in order to give coherence to the statute, the words redeemed and have not redeemed are given the construction for which we contend. Then our interpretation, and I said I'd make this point, that's consistent then with the policy of Section 37.7. There's three important points, and I won't develop them. I think the Tixes might say something more about this, but first of all, with the protection of creditors. Proviso 2 deals with solvency for the protection of creditors. So it prevents somebody from enforcing the terms for repayment unless the company had a state of solvency all the way through between the different dates. According to Primeo, Proviso 2 does not apply. Doesn't apply at all because you're not in Section 37.7 according to them. So the preservation of the protection of creditors simply doesn't appear as in part of their scheme. Similarly, we say the preservation of capital is not properly protected because the money goes out after winding up if my learned friend is right. And then I will come to the waterfall. And it also makes sense to be consistent with the policy of Section 37.7 that all people should be treated consistently regardless of the particular details of the articles in question. So on my learned friend's construction, it's driven by the articles. I've made the submission, and your lordships have it now, that the language in our submission, because of the particular focus on payment, is supportive of treating redemption as including payment. And I can just identify with us something like something like 9 references to payment in Section 37, which support that. We set them out in our printed case, paragraphs 41 and 42. And it is remarkable if 37.7 in particular doesn't work, doesn't have any application in this case. For 2 reasons. Firstly, because one would have expected that the legislature would want to know what would happen about payments which were being asked for after the onset of insolvency, not leave it to some other provision which is not dealing with redemption at all. And secondly, and we stand by the submission, that this gives Section 37.7 and Proviso 1 no operation. And I made the point by reference to Natixis's paragraph 21 of their printed case. If you take the R to redeem category, they either don't fall within 37.7 because they're excluded by Proviso 1, or they're outside 37.7 because on that hypothesis, they're not a case that has not been redeemed. As to other sections which are referred to by the Court of Appeal, I've mentioned Section 37.3c. That is in our submission neutral. It says nothing about what is meant by have not been redeemed. It's simply saying, providing that a company's articles need to set out the manner and terms on which redemption and purchase is to take place. And 37.3c doesn't come anywhere close to being a definition clause. And the board in Culross wasn't construing the meaning of Section 37 generally, or 37.7 specifically. So far as 37.3g is concerned, given the time, I will simply invite your lordships to note that we deal with that at paragraphs 88 to 97 of our printed case. There's two or three other points I want to make.
Well, I think we did interrupt you quite a lot, but you're into injury time. Yep.
Yes, my lord. As to the, I can deal with this quickly, but as to the point about the Court of Appeal refers to the legitimate expectation of a redemption holder that once the date has come, he would get his money, he would be redeemed. That actually can be contrasted with what actually the same judge said in a case called DD Growth, which I think is on its way to your lordships, at I think paragraph 50. And I'll check that reference, but subject to that, I invite my lord to have regard to it. And that says, well, you can't say the legitimate expectation of a shareholder in circumstances where the company is in a state of financial difficulty and where the articles include a power to suspend. You can't assume.
So which case is this?
This is DD Growth.
Well, what's the reference?
Tab 6 of the authorities bound back.
Okay.
It's paragraph 50, isn't it?
Paragraph 50. Right.
Yeah.
Forty, I'm sorry,
Yes.
40.
Yes. Yep.
And on the waterfall, please, would your lordships have in mind our case, paragraph 15, and this is the last point I will make. Next to the last point I will make. Paragraph 15, where we point out the inequity and the problems of the construction proposed. And paragraph 121 of our case, where we set out, including by reference to textbook, including Fletcher, which I referred to before.
Yeah.
And this ties in with the point I was making about the case made by Reichmuth. It's a very strong indication.
I thought we'd had this point.
Yes.
This is 49 and 37 all over again.
Yep.
Then we also contest, and that's in our printed case, so I won't repeat it, whether the claim of Primeo is provable, and we set that out in our printed case, so I won't repeat that. And so far as the point specifically made by Reichmuth, well, Mr. Atherton may deal with that, but I want to make the proposition that the articles, please, have always included the power to suspend. At the time that they were taken, they included the power to suspend. So it's not legitimate to separate the power to suspend from the rest of the articles, and therefore to say that the date for redemption remained unchanged in circumstances where the articles say that if there's a suspension, then the right to redeem is suspended also. I'll leave anything else to reply.
Thank you very much indeed, Lord Goldsmith. Thank you. Mr. Tregear?
I have no further submissions. Thank you.
Smith?
Thank you, my Lord. Primeo's position is obviously that the decision of the Court of Appeal was correct. Contrary to the case advanced by the appellant, we say the relevant claims of Primeo and the other December redeemers as creditors to the unpaid redemption amounts don't rank behind all the other liabilities and only alongside a return of capital to existing shareholders. Rather, as the Court of Appeal held, while those claims rank for payment behind the claims of ordinary creditors, they're required to be paid before existing shareholders are entitled to any return of capital. Now, for the purposes of these submissions, subject to your lordships, what I was proposing to do was briefly summarise certain key features of the facts, which we say are important in determining the appeal, then to deal quickly with the statutory scheme in winding up, and then section 37 of the company's law, which is obviously relied on by the appellant.
Could I just ask you,
Yes.
Mr. Cameron, where do you stand on 49G? Do you support the Court of Appeal on
Yes, 49G applies to our claim.
and you'll tell us in due course how that fits in with the other
I
later redeemers?
absolutely.
That's on the basis that the right to payment is derived from the contract of association.
That's exactly right. So it's derived from what Lord Brown-Wilkinson described in Soden as the statutory contract of membership. The right to redemption amount arises from that contract.
Well, it's got to be a sum due to any member of the company in his character of a member,
Yes.
by way of dividends, profits, or otherwise.
Yes.
So, does Lord Brown-Wilkinson deal with the same phrase?
He does. There's a separate line of authority which deals with the meaning of member in 49G. And in the specific context of 49G, member includes a past member. It doesn't.
He's exercising rights derived from his contractual rights when he was a member.
Exactly. And
Well, I think, I mean, there seems to be a decision of Mr. Justice Edward Bannister in the opposite direction, but that's a lone wolf.
well, it is. I mean, the meaning of 49G, the meaning of member in 49G was the subject of a decision of Mr. Justice Roxburgh in a case called Reconsolidated Goldfields back in the 1950s. It was then followed by Mr. Justice Slade in the Campagna de Electricidad de Buenos Aires. And I'll show your lordships those authorities. But within the specific context of 49G, it's been said that by virtue of looking at the different provisions within that section, member must mean past member. Now that is putting a strained construction on member because it's actually defined in the company's law to mean an existing member. But one of the reasons why there may have been a bit of confusion in some of the cases being advanced is it hasn't been quite appreciated that there's that distinction.
Well, perhaps you don't put the same strained construction on member in section 37.
Well, you don't.
And it may be that that's how you get out of the dilemma.
That's exactly right. That's exactly our position. And the confusion that has arisen, or which may have arisen, is I think people may have read member in section 37(7)(b) as including a past member. And that's not right. Actually, the position is the other way around. It's in 49G that includes a past member, but that's a particular strained construction that's been put on that statute as a matter of judicial interpretation.
I was actually highlighting the point because you do draw a distinction between what might appear to be the same phrase
Yes.
in section 49G as compared to section 37.
That's absolutely. That's
B,
part,
and I was hoping you would explain that at some point.
absolutely, and that's part of our case. And we'll come to Consolidated Goldfields, and you'll see Mr. Justice Roxburgh says that he's effectively driven to construe member in what he says repeatedly is an unusual sense, and he does have to construe it as past member. In that case. But I'll show you, Lordship.
So the result is that all your pari passu with the late redeemers, are you? Is that where it ends up?
Well, Mr. Rabinovitz's clients, no, we would rank ahead. They would then rank after hers, and then the members would come last in relation to their capital. We described that in our case, but I'll take you to that because that's part of the statutory scheme in winding up. I was just, before doing that, I was just going to take you to the facts because it is in our submission very important to look at the provisions of the articles as a starting point. I know you've already looked at those to some extent, but they are in our submission very important. Now, we're obviously concerned with the shares which were the subject of the redemption request for a redemption date of the 1st of December 2008.
Yeah.
Now, the first point, which is common ground, as I understand it, but which is very important to emphasise, is that those shares were redeemed under the articles on the 1st of December 2008 in the sense that the December redeemers ceased to be shareholders in Herald on that date. If we could perhaps just take up the statement of facts, which your lordships will have in the core bundle.
Yeah, we referred to this, yeah.
Yes, you've already looked at some of these provisions,
Yeah.
so I do apologise for the repetition, but it is in our submission important.
Understand.
If we can start with Article 20, sub-Article 2, on page 826 of the record.
Sorry, which paragraph number are we at?
We're looking
sorry, you're going to the articles themselves.
No, I was going into the articles within the statement of fact, so it's core bundle tab 7.
Paragraph?
Paragraph 8.
That's very helpful, thank you.
Article,
8I, yep, I see.
Article 22.
22, yep, thank you.
And your Lordship sees
Yep.
here, particularly in the penultimate and final line, that expressly the redemption takes effect on the redemption day.
Yes.
And the redemption day in our case
Right.
was the 1st of December 2008.
Yep.
Now, in addition to that, over the page, Article 23 of the Articles, the Articles also expressly provide that on redemption, the shareholder shall cease to be entitled to any rights in respect of the shares. So all of his rights as shareholder are removed on that date. And that would include, for example, the right to rank as a shareholder in any winding up. That goes on that date. It's removed under the Articles. And the article goes on to say, consistently with that, he's to be removed from the register of shareholders. And the share so redeemed will be available for reissue to a new shareholder. Now, in fact, at the relevant time, the effect of the Companies Law was that the share would be cancelled at that point. It's section 37(3)G, which says that when a share is redeemed, it's cancelled. So, notwithstanding Article 23, the effect of redemption under the Articles was that the share would automatically be cancelled. But the important point is it's clear in our submission that prior to the start of Herald's winding up, the December redeemers had ceased to be shareholders in respect to the relevant shares. The shares had been redeemed under the Articles, they'd been cancelled, and the register of members had been amended accordingly. And as I think your Lordships observed earlier, that's reflected in paragraph 16 and 26 of the Statement of Facts. If we look at paragraph 26 in particular, it's common ground
Yes.
that as required by and in accordance with the Articles, the December Redeemer shares were redeemed within the meaning of the Articles on the 1st of December and removed from Herald's share register prior to the commencement of Herald's winding up. So the first point is, plainly we'd cease to be shareholders, we'd cease to have any rights as shareholders. The converse of that is that it's equally clear that under the Articles we had become creditors of Herald for the unpaid redemption amounts. And again, that's what the Articles expressly say.
That is a right derived from the Articles, which is not extinguished.
Yes.
Notwithstanding the rather large-scale words of the article.
Absolutely.
Yep.
So it's certainly a right that's derived from the Articles, and it's a right.
That's article.
It's Article 18
Yep.
I.
Thank you. Yeah.
And your Lordships will see, it says, participating non-voting shares to be redeemed under Article 20 shall be deemed to be outstanding until and including the valuation point, as at which the net asset value per share is determined, and after that time, until the price paid thereof shall be deemed to be liabilities of Herald. So, in our submission, it's clear that prior to the commencement of the winding up, the December redeemers had become creditors of Herald for the unpaid redemption amounts, and those unpaid redemption amounts were liabilities of Herald, and those redemption amounts were unpaid liabilities of Herald as at the commencement of its winding up.
That's a convenient moment.
Sorry?
Is that a convenient moment?
That is a very convenient moment, my Lord. I'm grateful.
We'll resume again at 2 o'clock. Thank you very much. Court's now adjourned.